policy. And they probably were confident enough because they saw the amount of assets. They probably thought, again, in their heads, I bet this guy's got a bigger policy than most because he's just got too many properties. So again, they're making deductions based on what they're seeing. If they can't see things, they're going to make a different deduction. Okay? About 75 to 80% of all those lawsuits are under $1 million. So typically we recommend a $1 million, at least a $1 million umbrella policy, because then you're going to get 1.2 to 1.5 total. Because again, the umbrella policies add on to whatever you bought originally. So if you bought a $250,000 policy and you get a $1 million umbrella, you actually have 1.25. Okay? So, and again, that's just your risk averseness and your risk tolerance and what, you know, if you want a $2 million, about 95%, 96% of all lawsuits are under $2 million. So that gives you kind of a reference point of what kind of insurance you might need. Insurance claims are denied. Just kind of be aware of that. That does happen. And damages may exceed your limits. Okay, so again, it's a great first line of defense. It should not be your only defense. And it's so funny. I love talking to like these old timers. Jeff's probably going, yeah, they're like, well, I've owned 50 rental properties my whole life, never had a problem. I've got insurance. I'm like, okay, I get it. I'm not going to convince you otherwise. That's awesome. And when you're ready to sell your portfolio, come give me a call. So yeah, you know, but everyone has their own sort of risk tolerance and what they're comfortable with. I'm a worrywart. I just am by nature. So I overprotect everything. Probably overcomplicate my life because of that, right? Other people are like, don't care. So just kind of know your own kind of limits. Okay, must come up later. Okay, so the LLC, we're going to talk about that now. So here's good old Ian again. So we're back to kind of our story. He's going to set up an LLC. Now look, Ian is what? Is he single or married? Single. He's single. Okay. So when he sets up his LLC, he doesn't have any business partners yet. Doesn't work with anybody in real estate. In fact, he's just starting to go to RIA, so he doesn't really know anybody yet. But he's found his first deal, and he wants to pick up this rental property. Okay. So he comes to me and says, Jeff, I'm getting my first rental property. I'm like, awesome, let's set up your LLC. Are you working with anybody? No, I don't have any partners. I'm like, do you have a spouse? No, I don't have any spouse. You know, any kids maybe from a previous marriage or something, or just floating out there that you don't know? No, I don't have any kids. And I'm like, okay, that's, no worries. So we're going to set up a single member LLC. Okay? And unfortunately, that's what we call it, a single member LLC, because this is just one member, just one owner of the company. Now, single member LLCs are a little bit strange in the US. Okay? Well, I don't even know if they have LLCs in other places. They don't. So the single member LLC, and you see this on chat boards like in Bigger Pockets and stuff, and everyone's talking about single member LLCs and there's no protection and blah, blah, blah. The charging order protection. I'm going to give you kind of an example of what charging protection order is and why we have it. Okay? So let's, for example, Jordan and I, since he's right up front, Jordan and I are going to do a partner deal, and we're going to go buy an 8-plex here in Salt Lake. Okay? We're going big. And so we buy this, between my cash and his cash, we've got enough for the down payment, and the seller's going to finance the rest. So Jordan and I set up an LLC. We're the two members of it, 50-50, because we get along. We're not worried about like who's going to have final say and control, which is a partnering class and a syndication class, which I'll be teaching in September. So be on the lookout for that. So Jordan and I set up this LLC. We're the two members, 50-50. Awesome. We buy this house. It's seller financing. We've got about $400,000 of equity in it. We're like totally pumped. It's got great cash flow. And then Jordan, goes out drinking one night with his buddies, and we probably know who those buddies are that love to drink. And he's driving home, and really he's a good guy. He's only had one drink, but he's a little bit of a lightweight. And so, but his blood alcohol content is just over that 0.05 limit that is now in Utah. So 1 or 2 drinks, you're drunk. He's not impaired. He can pass a field sobriety test. He can walk a straight line, he can do backflips, land on a balance beam because he used to be a gymnast. He's fine. But he gets into the accident and looks like maybe there was some swerving or something, or maybe some ice. So the cops think, well, they can smell a little on the breath, so they've got probable cause. Say, you know what, we're going to take you in for impaired driving. They do a blood test, and now, even though he thought he was fine and everything like that, he's actually legally drunk. And boy, once the plaintiffs see that he's also legally drunk, boy, is that going to just shoot up the damage awards. Okay? So there's now a $2 million judgment against Jordan Atkin as an individual. Okay? That's personal liability because he was in a car accident. I know.
Get me out of it.
Get me out of it, Jeff. And I will do my best. So the plaintiff's like, okay, we're owed $2 million. What assets does Jordan have? So now Jordan's got some other assets they're going to look at. But now they're looking at this eightplex that he and I own together, right? And he's got ownership in it. During this discovery phase, they forced him to turn over documents. So they know about this LLC. They know that he owns 50%. And they want half that equity. They want that, $200 or $200,000 of the $400,000 equity that belongs to him. And so the plaintiffs are telling the court, hey, we want to go after that property, force that LLC to shut down, liquidate that house, cash it out, and give us the cash. Okay? That's what the plaintiffs want. Now, Jordan owes them money, so it's a real debt. It's a judgment. It's on court record. He owes that money. Okay? But they're looking at this house, this eightplex in the LLC, and if the court jumped in and said, yeah, that's Jordan's asset, we're going to liquidate it, cash it out, and give it to the plaintiffs, who just got screwed? I did. Did I do anything wrong? No. That's a good one, yes. I should learn not to I would partner with Jordan. Yeah, yes, that's my partnering class, so take that one. So again, the court sees that and goes, that is just not fair. It's not fair that an innocent person is going to suffer and lose money or damages or whatever simply because he happens to be partnered with somebody who did something wrong.
So that was just a partnership.
This was a partnership. Yeah, we were 50-50 members in a 2-member LLC, partners on this deal. Okay? And so the court will not liquidate that eightplex. That eightplex is protected. It's not going anywhere. It's going to stay in the LLC. We're going to still own it. I'm going to own it. I have my 50%. I'm also the manager, so I can control it. And what they're going to get is a charging order against Jordan's interest in it. So if we ever do make a distribution or sell the asset and cash it out and distribute it to the 2 members, me and Jordan, okay, I still get my half. I still get my half, so I'm good. But his half would go to the charging order and to the plaintiffs in this case. Okay? But what do I do as the manager of the LLC? I don't make any distributions. I decide, no, we're going to keep all the money in the business. Can you do that in an LLC? Yes, you can. Anyone really good with taxes on LLCs? But what happens to the money can stay in the bank account, but what does your accountant do? He files a partnership tax return and issues K-1s to the 2 owners, telling each owner how much money they need to report on their income, right? So I get mine, I report that. I don't get the money, it kind of sucks for me, and I'm going to pay the taxes on it. But the K-1, instead of going to Jordan now, doesn't go to Jordan anymore. It goes to the heirs or the people that sued. So they're going to get a K-1 and have to claim that money on a tax return and pay taxes on it, even though they're not getting any of the money. No one wants to sit in that position for 20 years. Because I'm the manager of the LLC, and I'm like, that sucker, we're riding that one out. That's cash flow cow. We are not selling that, right? And so they're going to, year after year, they're going to be paying taxes on money that they're never, and may never get, right? So what it usually does is it kind of forces them to settle for even lower amounts, just to get some cash now and leave.
In Utah, how long will the judgment last? Is it 10 years?
It lasts 7 years, but you can keep reinstating it.
Indefinitely?
You can do it indefinitely. But a lot of people forget, depending on the size of the judgment, if they don't renew it with the court, you have to actually supply paperwork to the court and say, yes, I want this judgment renewed.
Well, you're going to write that out for 7 years and then another.
And they'll forget, and they could forget too. And if they don't, then they've lost the judgment. If it's huge, the attorneys, especially if they're contingency, they're probably not going to let that happen. But again, it just puts them in a really tough position, and they're just going to be more likely to settle.
What if Jordan has 51% of the company?
Doesn't matter.
Okay.
They would get 51% of whatever is distributed. Yes. Now, we're going to talk about the operating in just a second and why I create the operating agreements the way I do. Jeff, did you have a question?
Yes, but I'm going to wait.
Okay. Because I might answer it.
Like throughout the period of time that you guys are partners, can you do distributions to yourself but not to him?
No. No. Can't do distributions just to me and not to him.
Can you repeat the question?
Oh, yeah, sorry, thank you for reminding me. The question was, during this time period, could I make distributions just to myself and not to Jordan? No, and that's a rule we're going to see when we talk about the money and the commingling funds. If a LLC makes a distribution, it must distribute it to all the members according to the operating agreement, which is usually by their percentage interest. So a distribution is mandatory to go to all the partners or all the members. What can I do, though, to get me money and not Jordan?
You're the manager. Borrow, right?
I'm the manager, so pay myself a fee, a salary to manage the company. I mean, it's not the kind of income I want. I like passive income over active income, but still I can take money out and pay myself as the manager. That goes to me as an employee of the company. And it's not a distribution, so it doesn't go to the creditors.
Can you borrow against your own LLC?
Yeah, you can borrow against your own LLC. Yeah, we pretty much say, make sure it's arm's length, market terms, in writing, because you can get into kind of the commingling kind of area, but you can do it. T?
Could that could that entity exchange the asset if there was no distribution?
Yeah, you could sell it and buy. You can do a 1031 exchange. You can sell it. You can move up, buy up. You can even cash out and leave the cash in the account, but I would keep the asset. Jeremy?
If the members of the LLC are married, does that?
The question is, if the members of the LLC are married, does that? Yes. By law, they do get. If they treat the LLC as a partnership, a married couple gets the same protections. So which means that married couple, even though they might file their taxes jointly, they need to still file a partnership tax return and issue K-1s to each spouse, and then let each spouse report it on the joint income. And a lot of accountants don't do that. A lot of accountants say, oh, yeah, you're the two members, but you file your taxes jointly. I'm not going to file a partnership tax return because it's all going to come back together at the end. No, you still want that partnership tax return so that you can go to court and say, look, we treated this as a partnership, so my partner gets this protection. One last question, then we're going to move on.
You mentioned cash out, so do you mean cash out refinance or like actual sell?
To do a cash out kind of refi, you're probably going to have to put it into somebody's individual name. We could probably put it into my name. I could refinance and put it back in.
Would the judgment consider that like a distribution?
I don't know. It's something you would actually have to probably argue and see what the judge says about it. Because you do have a legitimate purpose of refinance. That's a pretty legitimate purpose to change title. But you are changing title. It is coming out. Okay.
What if your property's in a community property state?
Thank you. I was going to send that. Community property states are a little different because in a community property state, husband and wife are considered a single being. So in community property states, we believe that a double member, a husband and wife, may not get this protection. You're still going to argue it. You could still file the partnership tax return. You could still do all these things. We don't exactly know. And it's probably going to depend on all the facts of the particular case. So it is a little more difficult in a community property state. Utah's not community property, by the way.
Arizona.
Yes, California.
Would, in this horrible instance, would my assets that are single member entities have the same protection, or could the court force
Here in Utah?
on those?
In your single member LLCs here in Utah, the court can force a sale. And it's even written in our LLC statute that this only applies to multi-member LLCs. So the question then becomes, let's go ahead. I'm going to talk about single member LLCs in just a sec. I thought I had that slide in there. Okay. Here's some structure in the LLC. This is kind of the education part. Okay. First, don't use your last name. We talked about that already. Use a PO box, type box. So we talked about that already. Manager manage. We always set up every LLC as manager managed. Because then when you're going out and representing yourself to tenants or whatever, you're representing yourself as the manager.
On these notes here, are they correlating with?
They
the
are.
slides that
They
you-
pretty much correlate with the slides. Or they should.
Okay.
Yeah. The notes on the paper should correlate with the slides. You can represent yourself as the manager of the company and not the member. And that's important for a couple of reasons. One, it's privacy, because just because you're the manager of the LLC doesn't mean you're also the owner. Okay? Some people might infer that, but it's certainly not proven. It's just you're the manager. When you're working with tenants, okay, you can say, hey, I'm just the manager of the company. I don't own it's owned by the LLC. I just work for the LLC. I'm the manager. Don't yell at me for your late fees. I don't have any choice in the matter. I'm doing what I'm told. It's a great excuse when you're collecting late fees or have to evict a tenant. It's not my fault. I'm sorry. I don't want to do this to you. The owners are making me. Okay? So that's one of the reasons we always do manager managed. It also makes it easier because if your company's member managed, anytime you sign something, all members have to sign it, which is kind of a pain. So it's better to vest it in a manager. And if it's manager managed, if you do run into a charging order protection, remember the manager has control over the company, not the members. So in a charging order situation, those creditors kind of come into Jordan's shoes, and they can't even get his membership. Okay? So here is the kind of the things that we put in our documents that you really want to have in your LLC operating agreement. Strong interest transfer restrictions. Jordan asked me about this just the other day and asked about he's got an LLC, it's just one, he's not done anything yet. Can he then change the membership to do other things with it, right? Because it hasn't done anything yet. I'm like, that's great, yes you can. But our documents come with very severe restrictions on the transfer of membership, because what that does, in the event that there's a lawsuit and a charging order protection, this keeps more barriers from those people coming in and trying to get control of the company. So if they were to get Jordan's, even if Jordan had 51% and they got his 51% membership, we can make, that's called an involuntary transfer. Okay? Jordan didn't want to leave the company. The court forced him out of the company. And they gave his interest to these creditors or these judgment holders, right? So now they're kind of part of the company. You can define in your operating agreement that involuntary transferred members are non-voting. So I don't care if they have 75%, they don't get a vote. Okay? So we put in strong, barriers to transfer. So we don't make it easy to transfer your LLC to somebody else because the core documents are restricted to give you this better asset protection. So there are a few more hoops to jump through. So when you do membership changes on our documents, you're essentially that all the members have to agree to amend the operating agreement to allow this new member in. Because unless the operating agreement is amended to allow that person in, that person is just considered an involuntary transferee. They got the membership through the court process, not because Jordan sold it. And then they have different rights in the company. Okay, does that make sense? So these are kind of the things that we built in. We make distributions solely in the manager's discretion. So I don't care if these people get 75% of the company, they cannot come in and say, you're making a distribution. Right? Because no, that's the manager's job, that's me. I'm Jeff and I'm the manager. So no, we're not making distributions.
The situation was reversed when you were in the accident charge, you
Uh-huh.
were manager, and they forced you to do so.
We restrict the way you change out managers, but what we would do is Jordan and I would appoint, as soon as it happened, Jordan and I would, as the two current members, change me over to the manager before the lawsuit gets too far. Yeah.
If you're acting as the manager at the time that the accident happens, then wouldn't you have employee liability, like
Great question. The question is, and it's a great example, if I'm the manager of the company, don't I have some kind of employee or employer-tenant? No. Why?
You're also an owner.
No. The two kinds of liability, right? As the manager of the company, when I'm talking about liability to employees or my tenants, that's a professional liability. What kind of liability did Jordan get in trouble with? Personal.
but if he's driving on the car.
Well, that's a different situation. Our example was that, the example was he was drunk one night. But let's say if he was working on behalf of the business, doing business duties, and his scope of employment is what they call it. This is not an employment class. If he's working in scope of employment, and then he hits somebody and kills somebody in a car while being the manager of the company on company duty, yes, then we're talking about professional liability, and the assets in that entity could be at risk, and but our personal assets would still be protected, because again, that's the professional liability, the corporate veil, personal. That's where you got to kind of always remember that this liability is coming from two different directions at once, and you protect from those differently. Okay, is that making sense? Buy-sell provision. A buy-sell provision is just a provision that says, if a member does want to sell, leave and sell their membership to somebody else, that they have to usually give a right of first refusal to the other members first. So that keeps control that Jordan just doesn't go off and sell his membership to Riley, who I can't stand and don't want to work with, because then I'm in a partnership with somebody I don't want to be in. So we can put those restrictions in too, so that Jordan can't just leave and dump me with somebody that I don't want to work with. Okay?
Will you restrict the valuation on the membership time in the agreements?
Can I restrict the valuation
Membership interest.
of the membership? By what do you mean by
So
that?
if they want to cash out, they want to sell their membership interest.
Okay.
Can you restrict it within the document before the company really gains
Oh,
a
absolutely.
lot of assets?
Yes,
So you can-
these are in our documents when we formed the company originally, right? And over time, you can amend those and even make them stronger, or you can make them a little weaker if that's needed for your business kind of thing. But yeah, we can make changes at any time. Here's a tip. Here's a pro tip. I've said this before at some of the RIAs when I teach. Okay, title insurance and changing ownership to properties. Okay, so what Ian is going to do, right? He's going to set up a single member LLC because he's single right now. Poor guy. Okay, but we're going to give you some options in a second. So he's going to set up this LLC, and he's going to buy his first rental. He's going to get non-owner occupied financing to buy his first rental, like all first rental people do, because they don't know seller financing yet. And so when he buys the house, how does he have to buy the house? Where are my loan officers? In his personal name. That's because a bank requires it. A bank says if we're going to give you a loan, we're going to loan to you as the individual. And why does a bank want to loan to you as an individual and not your LLC? Personal liability, because then they have got a broader range of assets to go after, and banks write the rules in our lives. Okay? So you have to buy the house in your personal name, and what does every investor do with their rental property immediately after buying it? They put it into their LLC. So they change title, take it out of their personal name and put it into their LLC name. That's great. You just protected your asset and you protected your personal stuff as well. The problem is your title insurance. Your title insurance covers the named insured, which is you as an individual. Okay? Now, I'm an escrow officer, so I know why this happens. When you buy in your personal name, your title company by default is going to issue you a homeowner's policy of title insurance. A homeowner's policy is more expensive, so your title officer is going to make more money. It also covers more things, so that's a good thing. I mean, it has greater coverage, so that's good. You pay more for it. Your title company, your escrow officer loves it because they make a bigger commission, because escrow officers are basically insurance salesmen. Okay? But a homeowner's policy of insurance only covers human beings. So the second you transfer it to your LLC, you've just voided your title insurance policy. Here's what you do. Here's your tip. This is probably worth your entire $200 fee today. When you buy a house like this and you're getting conventional financing, you got to buy in your personal name and you're going to immediately deed it into your LLC. Tell your title company that you want an owner's policy of insurance, not a homeowner's, an owner's. It's cheaper. The one big thing that it doesn't cover that the homeowner's does is boundary line disputes. That's kind of a big issue. So I've got a lot of clients that when they do get the owner's policy, they add in a boundary line endorsement to get that coverage, which does kind of increase the price. But the reason you want the owner's policy of insurance is because then you tell your title company, I want an owner's policy of insurance, and here's my LLC documents, and as soon as I close on this loan, I want you to put it into my LLC, and then I want you to give me an endorsement adding my LLC as an insured. And now you're covered. And the endorsement's $100 or $150, whereas a new policy could be thousands.
Is the owner's policy transferable to subsequent interest like a lender's policy?
No, you wouldn't take an owner's and transfer it to a lender's. There's very separate kinds of insurance.
I mean, not transfer it to, but transfer it like a lender's policy.
Oh, assign yes.
Will be assigned.
No, owner's policies are very different. Yeah, lenders' policies of insurance usually will cover the new lender when they buy and sell mortgages on the secondary market or assign a note and deed, yes. If you're a lender, that's a side note, but if you're a lender, make sure that the title policy does include and or assigns in it. Most do by default. But yes, that's a different, lender's policies assign very easily, owner's policies do not. Okay?
Jeff, again, so you're saying that when an individual purchases a rental property,
In their personal name, and you
name,
know they're going to put it into an LLC afterwards. Yep.
say they're buying on hard money, so they're going to get a lender's policy for the.
So they buy in hard money. So when you, good, this is another transactional tip here on the insurance side, not necessarily asset protection, but many people will buy a property with hard money force some appreciation, paint, carpet, whatever, increase the value, and then do a cash out refi. Okay? If you're going to do that, buy in your personal name at the beginning with the hard money loan. So you're going to take the hard money loan in your personal name. Do your rehab. Yes, you're going to run some risk. But then when you go to cash out refi, it's got to be in your personal name. And all banks, most banks, I got some loan officers here, have different requirements. Some want it out of the, if you did put in the LLC, some will actually make you take it out of the LLC for months before they'll make a loan. Others are cool with it, and they'll just take it out at closing, give you the loan, you can put it right back in. But to kind of protect yourself, because you may not know what bank you're going to work with at the cash out refinance, buy in your personal name, do the rehab, forced appreciation. Then when you do the cash out refinance, again, but actually the thing is, you have to tell it's at purchase, right? The owner's policy comes at the purchase, not at the refi. So when you buy the house in your personal name, still get that owner's policy, even though you're going to refi months down the road. Make sense?
They ask for that.
Yes. Yes.
Just to know that I work with private lenders that will only lend to,
They do that for licensing reasons. The question was, there are lenders that will only lend to an LLC and not to a human being, and that's due to banking and lending regulations and not providing a personal purchase money loan. Yes, and they will do that. Okay, so Ian just picked up his first rental. Awesome. Yeah, William.
What do you recommend for properties that I've had for a long time that I'm now that I set up my LLC and I'm moving them into? Are you recommending get a new title policy? Or
I leave that up to you. The longer you've had it, the more likely you're not going to run into any title problems. So if you've had it for 10 years and nothing's come up yet, and you've already passed most statutes of limitations, and it's going to be much more difficult to have a problem, so you may not need the insurance anymore. You can always buy more insurance. Title companies, insurance agents always want to sell you more insurance, so you can if you're worried about it. Okay, so he picked up his first rental, and so he put it into his LLC. So again, we got the orange box. It looks a little yellow, but we got the orange box. Okay, we got to kind of keep moving here. So we're going to kind of hang on questions because, I knew there was tons of stuff. This is awesome. So he has a rental property. There's a slip and fall at his rental. Okay, think about it. Take a second to think. What's protected and what is not protected? Right now, he's got a single member LLC with this slip and fall rental. What's kind of going on? Does anyone want to take a stab at what protections he has and doesn't have?
in my opinion, the LLC assets are at risk.
Are at risk, correct. The LLC assets are at risk. They are, yes.
Is there not? Or are?
Oh, his personal?
His personal.
His personal are? No. Which liability is this? Business. What protection do we want here? Corporate veil. And corporate veil comes with even single member LLCs.
So he is.
His personal assets are protected. This house is at risk. The plaintiff's attorney knows that this house exists. Obviously, they fell there. So yes, this is at risk. His personal assets are protected, as long as he runs his company appropriately, which of course Ian's going to do. Okay? Now here's the other liability. Now he's got his one rental, he's got his LLC, he's cool there, but now he gets into a car accident. Now what kind of liability are we talking about? Personal. What kind of protection does he want here? Charging order protection. Does he get charging order protection? No. So in this car accident, this house is at risk.
How much equity does it make sense for a lawyer to go after?
The vast majority of slip and falls are going to be less than $40,000. They know your insurance is going to cover that. That's probably what's going to happen. So from an equity standpoint and asset protection, that's not necessarily what we would take into our calculation. It's more of your overall family assets, your estate value, and what layers and additional protections to kind of protect the whole overall thing. Yeah. But obviously, the more equity you do have in a house, the more likely that they're going to attack it. And can they find out how much you owe on a house? Oh yeah. They can at least find the original balance on your mortgage, because that's probably going to be on the trust deed. Now, here's a great note. I didn't even think about this until just right now. Another privacy tip. Anyone know where I'm going with this?
Equity stripping.
Equity stripping is a good one. Yeah, we can talk about that. But that's not the one I'm thinking about.
Have the amount undisclosed on the trust deed.
Have the amount undisclosed on the trust deed. Your lender may or may not allow you to do that. Okay, that's up because the lender is going to create the trust deed. But if you've got pocket lenders, family, friends that are loaning you money, they can create a loan document that you owe them $100,000, so there's evidence of the debt. But on the trust deed, there's in the first big paragraph, when you look at trust deeds, there's going to be a bold dollar sign and an amount, which was the original principal balance on the loan. Okay? You don't have to write in the amount there. You can write in undisclosed on that. And a lot of my investors that have their pocket lenders, by default, have that undisclosed on all of their trust deeds.
So you're saying that you can have a note that says how much you're owed, but the deed doesn't have to show what it's saying?
No, no. The lender's got to be cool with that because the lender wants that on there because it's public notice to the whole wide world that he is owed $100,000. So back off, other lenders.
The lender might also want that to protect themselves. If you've got a $300,000 house and they've loaned you $150,000,
Right.
but they don't disclose on there that you have $150,000, that might be giving somebody else the idea of, well, I'll loan you more
That's
money
right.
on this as well, because
Yeah.
it's not disclosed. That makes sense.
Yeah.
Said that it's good to have a mortgage on a home so that they know you don't have that much.
Yeah, that's equity stripping. And that's another technique that investors use is equity stripping, where you take an asset, you secure it as collateral with other loans, so there's no equity in it and there's no reason for anybody to go after it. That is great. If you're going to do equity stripping, however, it has to be a legitimate debt. So if you think you're going to create a note and deed for $200,000 recorded on your property that you owe yourself or some business entity that you own of this and no money ever changed hands, yeah, the court's going to blow through that. But if if you like leverage, if you're one of those investors who likes leverage, some do, some don't, and you want to leverage your properties with blanket loans and all these other kinds of financing, you can strip all the equity out and use that money to go invest in other projects. But that's a legitimate loan.
That's the third party.
And it's to third parties. Yeah, you try and do a loan with just yourself, to yourself, and no cash actually changed hands, yeah, that's not going to work. Yeah.
On that charging order protection,
Uh-huh.
is that just because it's a single? Okay.
Yep. So, question is, how do we get Ian some additional charging order protection because he's a single guy?
Make his brother an LLC member,
Yeah,
1%.
sure. I don't like 1%. I'd probably do 10. Yeah.
Good non-voting.
Because the court can look at things and call it de minimis, is a legal term for that, that it's not enough, that you did it just to pretend that there was another member. But if you want to truly partner with your mom or a child, maybe, you can add other people. Just remember that when you do add members and you make and this is a big mistake that I see families do all the time, especially in family limited partnerships that they bought at some event, okay? Set up the family limited partnership, it's mom, dad, and 3 kids, all right? But it's really the mom and dad's business and it's all their rentals. So when they took money out, they didn't give any money to the kids. They just stole from their children. I mean, their children are partners. That's a legal partnership. Right? You created a legal document, a legal partnership that is identified by the law with protections in court, and you just didn't give those kids who are partners in the deal any money. That's commingling, that's fraud, that'll blow right through your protection. I see that all the time with family limited partners because they weren't taught that when you make a distribution, you have to give it to the people that are owed the money. You can't make your kids an owner and then not treat them as an owner.
Could it be in form of wages instead of?
Oh, absolutely, yes. And that we get into, that's like super advanced and tax planning, and you can bring in kids, you can pay them and start gifting them over time and distribute. Yeah, there's lots of things you can do to kind of move your assets in cash to children to cover certain things, and yeah. Okay, so he could establish a holding entity in a state that provides charging order protections on single member LLCs. Wyoming is one of them. By state law, Wyoming does, in their little code, their statute, it does say that the charging order applies to single member LLCs. It's not been super tested. A lot of lawyers aren't really confident in that. And the reason they're not really confident is because where did the idea of charging order come from? Why did the court protect me in our situation with Jordan? Innocent parties, right? The point of charging order protection is to protect innocent people. And so, yes, state law says you get the protection, but will a court, well, who are we protecting here? With this charge, who are we protecting? There's no innocent party to protect, okay? But out of state, Wyoming, single member, better than nothing, right? Because it is still at least an argument that you're going to get it, and that raises their bar, right? So not are they just suing you as a single member LLC, they've got to get past this Wyoming state law and somehow argue that the state law does not apply. So it's going to make their job harder. You can create a corporation to partner with. That's the one time we do set up corporations. So you set up an Inc. that owns 10% of your LLC. Or you can establish an asset protection trust. That's later today. Okay? Okay. Whoa, congratulations, Ian. You just got a second rental property. Okay? So now that he's got two properties, he's got one LLC, he's got his second property in there. Now he's got to slip and fall at his second rental. Okay? So now think, what's protected and what's not? We're going to say, and for the record, he still is a single member LLC. We'll just keep that, because he's going to get married
So does
one day.
both properties are in the same LLC?
Both properties in the same LLC. Both are at risk, even though he only had problems with this one. Because in a lawsuit, who's the attorney representing this dude? Who's he going to sue? The owner of the real estate, which is the LLC, and now the LLC is the named defendant, so anything that LLC owns is at risk. Okay? So what are we going to do? The series LLC, because everyone here is Utah, right? I know out-of-staters, okay? I sometimes do teach this to out-of-staters that in some states don't have series LLCs. Where did the series LLC come from? Very, very quickly. In the old days, and I loved it, so in the early 2000s, when clients were picking up a lot of rental properties, I would set up a holding company, mom and dad, so multi-member. That was awesome. That holding company didn't do anything, but every time they picked up a rental, what did I do? Created a sub-company of the holding for every single rental. I loved it. I made lots of money, okay? Because I set up lots of LLCs, okay? Now, my clients had a big legal bill. They had a ton of bank accounts, and they had lots of tax returns, and it was just very expensive for them, okay? So about 18 years ago, states started creating what are called a series LLC, and the series LLC is it mimics that same holding company, sub-company structure. So it's the same structure, but it's all contained in a single entity, a single LLC, one filing with the state, one operating agreement, one bank account. If you need more information on the series LLC, our guidebooks on the client info page on the law office website, we have our LLC guidebook. First half talks about LLCs in general, and it talks about some liability too. The second half talks about the series LLC and how they work. Okay, so if you need some refresher on how series work, certainly review that. But here's what it looks like visually. It's a single LLC. It's called Ian's Rentals LLC. We converted it. Because remember, he set this up a few years ago when he picked up his first rental. But now that he's got two, he's like, oh, now I want more protection. I don't want to put both, and he comes to me and says, do I need to set up another LLC? I said, yeah, we can do that, but why don't we convert it? Actually, my first question is, what are your goals in real estate? Oh, I want to pick up a big portfolio of rental properties. Awesome, great goal. Let's set up a series LLC for you, and we'll take your current one and we can convert it. So you can keep the name, you keep the EIN, you can keep the bank account, you can keep your tax record. It's really nice. We take your regular LLC and we convert it into a series LLC. And then Ian's going to retitle the houses in the name of the series. Again, how we do that is in the guidebook. But each one of these series, even though it's part of a single LLC, they act like little sub-companies. And they're independent for liability purposes. I thought I had a picture of a slip and fall. I don't. Okay.
Jeff,
Uh-huh.
does this PowerPoint be made available for us?
Yeah. I'll send this out to you.
For somebody to go to LLC to series, do you have to file something with the state or is it just in the operating agreement?
It is something filed with the state, and it's a brand new, different, highly specific operating agreement. So yes, it is not something that you can do yourself at all, because you can't create the operating agreement that works unless you're a lawyer. And to my knowledge, even the online places don't do these. Maybe they do, but I don't think I've ever seen it.
We establish, or if we buy rentals in states outside of Utah?
We'll get there.
have a-
We're going to get there.
Okay.
Yep, how to hold title outside. Yep.
Now, do you have to maintain each series 1, series 2 with its own checkbook and then it's?
We do recommend that you treat this like its own company. So its own little minute, its own record keeping, its own name. Title is in a very specific name. Your lease agreement will list this series as the landlord, not the whole LLC. And I've got some instructions on a later slide about that. So yeah, you treat it like its own company, but you can use one bank account. And we're going to show you that. I got a diagram on how to.
So one
One bank account, yep. Separate books, separate bookkeeping. So if you use QuickBooks or Quicken, any kind of software program, you can categorize the transactions per series. So you can keep, essentially it's one book, but they're categorized differently.
Chart of accounts got multiple.
Yeah, your chart of, maybe it's your chart of accounts. Honestly, if you're going to use Series LLC, find a good bookkeeper. Because they'll know exactly what they're doing. They'll know exactly how to do this. Because it's going to act like, how many of you do property management for others? I don't have any property managers in here. In the back, okay? So when you do property management for others, so you've got clients, how many bank accounts do you have for your property management company?
I do it through equity.
So the property manager only has one bank account, but all the rents from all the clients go into that one bank account, but that property management company does separate bookkeeping for each client. That's what you need to do. It works like an escrow account where you're holding money for lots of different clients. Okay? So your bookkeeping does get a little bit more intense. Not intense, a little more work. Just hire a bookkeeper, seriously.
Find the bookkeeping and
Yeah. Yeah, once you get kind of QuickBooks set up, it's super easy. So once you know what you're doing, it's actually quite easy. Okay? Okay, we got to keep going. So look, okay, now Ian, he's got his first two rentals, Utah Series number 1, that's what he called that. Utah Series number 2, that was his second house. Now he's got what he's called Ohio Series number 3 because he bought a house in Ohio. Okay? So that brings in some more complexities if you start buying real estate outside of your home state. And for all of us, that means Utah. Okay? So what is protected? Well, right now he's got, if there's a slip and fall here, no worries. It's just this house is at risk. It just stays right there. This is separate. This is separate. Okay? So here are these instructions for what you do if you're going to pick up rentals or property or assets outside this state. Okay? It's kind of focused on real estate since we're all in real estate. We'll just stick with that. Okay? You could set up a sub LLC in that state, but that's owned by your Series LLC. That's an option. You're going to have a registration fee, a filing fee, renewal fees, and probably a registered agent fee. Because remember how all LLCs require a registered agent? You're going to probably have to hire somebody in that state to do that. So it's going to add on some costs. You're probably going to have to file a tax return in that state. Okay? But again, it's an option. You could register your LLC in that state. Let's say you want to own that Ohio property and you want to self-manage it. Okay? Well, you can register your LLC to do business in that state. If that state doesn't authorize Series LLCs, we don't know exactly yet how that's going to play out and whether or not that state will consider the Series its own little company. We still recommend titling it in the name of that Series if you can get away with it, because that will depend on the title company and the county recorders. Remember how I say you have to deal with other parties now? You just can't create your own business and do it your way. You have to comply with their regulations. So it may or may not work, but if you are going to manage it, you do need to register that LLC in that state because that LLC is conducting a business. It's managing the property. That's a business. That's different than if you want your LLC to just hold title. So if you hire a property manager in Ohio, you can title that property in your LLC and not register the LLC to do business because it's not really doing any business. It's just holding an asset. So whether or not you have to register that LLC in the other state depends on how much, whether or not your LLC is actually conducted in a business of management. Okay? My suggestion is use the asset holding trust. We're going to talk about that just after the break in a few minutes. Okay? Now, does Ian need a family living trust at this point?
Yes.
Yes. He's single though. Still get his family trust set up because he does have assets. He's now got a business entity. Okay? If he dies, that business entity is going to end up in probate. So he wants a family trust for that, and we can connect the LLC to the family trust. That's another slide. And if he sets up kind of his trust and all these entities and protections, even as a single person, and then when he does get married, if he keeps all of this separate and structures it correctly, he can protect these assets from a future ex-spouse. Okay, so that does happen. Okay, so here we've got his Utah house, his second Utah house, his Ohio house, and now he picks up a duplex. And the duplex is here in Utah. Okay, so he's really moving forward. He's doing great. I'm completely comfortable sticking that duplex in a series LLC. I think the series LLC works great for single family residences up to 4plexes. Okay, so go ahead and stick all your little plexes, I should call them plexes, in there. Once you get above a 4plex, you get into kind of the commercial or apartment building. We'll get there a little bit later. So again, we're just growing with Ian as his assets grow and the kinds of assets he's protecting, okay? So right now, each of these for liability are for slip and falls or business liability. All of these are separate, so that's great. So if he has a slip and fall of the duplex, the Ohio house, the Utah house, these are all protected, okay? If he sued individually, not getting married yet. If he sued individually, what's still at risk? Personal liability is going to come after all of these, okay? Because he still has a single member LLC, okay? At this point, if he had come to me, I'd be like, dude, I think we should figure out a way, because unless you're going to get married real soon and want the wife part of all of this, at this point, I'd probably start discussing other ways to get that protection, even as a single person. Because now he's building his assets, right? When you had one rental in there, hey, that's fine. He probably has $10,000 in equity on your first rental because of financing kind of thing, right? So not a lot of asset, no need to get complicated in the protection structures, okay? But he is now building wealth. So he's had this for a few years, he's had this for a few years, he's got this, and now he's got a duplex, he's got some great cash flow, he's building up some assets. But lo and behold, good old Ian, he's now getting married. Congratulations to Ian. He's going to marry Isabel, and they're going to buy a family house. Okay? So what's their next step? Ian's going to add, because they're in love, and everything's going to be good, everything's going to work out. He's going to make Isabel a 50% member of his series LLC. Okay? She'd get half of it anyways, unless he did his protection structures in advance and kept them separate, which he can do. But we're not going to go down that road right now. Okay, so he adds her to members of his series LLC. What does he now get? Charging order protection. Okay, so that's great. That's a great thing. And they're going to set up their family trust. Okay. Oh, I thought it was, we'll go on to that. So that's where they're at now. So he's got a multi-member LLC for additional protection, and he's got his family trust set up. And we're going to put the house into it too in a couple slides. I thought it was next. I want to quickly, so I'm running a few minutes behind. The family limited partnership. How many have a family limited partnership? One or two. It's an older structure. The family limited partnership has been around for about 100 years. It's what the wealthy have always used for the charging order protection because it was a partnership. And there was at least one member. And so they would create these family limited partnerships to act as holding companies for everything else. Okay? About 30, 40 years ago, states started allowing LLCs. And the difference between the partnership and the LLC, in a partnership, there has to be a general partner. So there are limited partners and a general partner. The limited partners get all the great liability, corporate veil protection. So if there's a lawsuit, those limited partners, they're not getting sued. But what about the general partner? The general partner is always going to have liability. That's the problem with a partnership. The general partner has liability. So when they started creating these LLCs, back in the early 80s, everyone was kind of jumping on the bandwagon of these LLCs going, hey, wait a minute, we get the same partnership benefits and there's no general partner. All the members get the protection. This is awesome. And when they first came out, all the lawyers, especially the old crotchety ones, were like, oh, I wouldn't set up an LLC. It's not been tested in court. We don't know, there's no general partner. So there's, someone's got to be liable because that's the way it's always been. Yeah, and then now 40 years later, everybody uses an LLC, which is why when people say, hey, well, is the series LLC, is that? No, it hasn't really been fully proven in court yet. I'm like, but, LLC law gave the protection in just LLCs, and the state law says series LLC get these protections, and so that's what the state legislature agreed on, and the governor signed it. That's law. So at least we've got that baseline law that says we get this. So that's why I still like these. And of course, they've been around now for about 18 years. So the family limited partnership is a partnership. There's limited and general partners. It does give the charging order protection, so that's great. The general partner is still liable. And so and then the construction of it is, the documents look identical to the LLC documents. They use different terminology. They use partners instead of members, and They use partnership instead of company. But it's the same, the content is the same. All the transfer restrictions, that the general partner has control over distributions, all of that is exactly the same. So when we do use family limited partnerships, they act as holding companies for other entities, usually other LLCs. So the family limited partnership doesn't do anything. It doesn't engage in business. It doesn't take on debt. It doesn't take on risk. All it does is hold either cash accounts, stock and bonds, and then it will own other business entities that then do the work. Okay? So here is the investors, Ian and Isabel. Isabel also just inherits $100,000. So now they've got some cash. Okay? So they've got their 4 series, Utah 1 and 2, the Ohio 1 and the duplex that are in their series LLC. Now I put this little LLC box inside this box. What do you think I mean by that? Because you're going to see that a lot. It's owned by. It's been funded into, which means the owner of Ian's rental is no longer Ian and Isabel. The owner is the family limited partnership, and the family limited partnership is owned by Ian and Isabel. Okay? And later slides when I talk about money, I've got them kind of in a different structure so you can see things a little differently. Okay? And notice they put their cash in here too. Now the cash can go right into the family limited partnership because does cash get sued? No, they go after the cash, but the cash itself doesn't get sued. Just like stocks and bonds, you're not going to, stock and bond is not going to end up, getting sued. It's just an asset. So any asset that doesn't have liability, we're fine sticking in here because, again, if this was something like if this were a rental property and then there's a slip and fall of that rental property, who's the lawyer going to sue? The owner of the house, which is the family limited partnership, and then anything the family limited partnership owns, which then trickles back down to the LLCs. Okay? So again, we're getting layered. We're getting a little more complicated. I'm seeing a few glazed faces. Okay? So the primary residence, where do we stick that? In the living trust for now. There's no protection here. We'll talk about that later, but that's in here because that's pretty standard. This is kind of the standard structure for most families, kind of at this point. Protecting this is a little more complicated and expensive, but we're going to get there. Okay? But right now, they've got the cash protected from personal liability. They got the rentals protected from personal liability. They got the separation here, which is really great. So they're in a really good, strong position. And this is great. Okay? An LLC can do the same thing as the FLP, which is why we don't do this structure very often anymore. We can create an LLC as the holding company, and then a series. In fact, we can create an LLC as a holding company and have like 10 different series LLCs, with 10 properties in each. You can have 100 properties kind of all under this umbrella. So we don't do a lot of these anymore. We would typically set up an LLC as the holding company. Okay, any quick questions before we can do a quick, maybe just 5 to 10 minutes, use the bathroom, get some drink, because we do got a lot of content. Any questions up until this point? Jeff, yeah. And I'll leave that picture up so you can let that soak in.
So really quick, going back to when Jordan killed all those people.
Sorry, Jordan.
So they get a charging protection order, but is there...
They get a charging order, right, against Jordan's interest.
Right, but is there a judgment that actually attaches to the property or no?
The judgment will not attach to the property. Why?
Because you're still...
Because it gets titled in the LLC, and the LLC wasn't sued. The judgment, the debtor on the judgment is Jordan Atkin, an individual. So there's no lien is attached to the house at all.
So how does the plaintiff secure their interest? So if you sold it, how does
So step number 1 is the lawsuit.
Right.
The lawsuit results in the judgment. Jordan can't pay it. He doesn't have cash, right? Because if he had the cash, he'd just pay it and he could go away. But he doesn't have cash. So then the next step is another lawsuit to enforce the judgment. And at that point, that's where courts garnish wages, force liquidation, sheriff sales. And in that process, they would then create an involuntary transfer of his membership interest to the creditors. That's the charge and order protection. It comes with the second court step.
Okay, but no judgment against it.
No judgment at the LLC or the property or anything. I still manage it. I can control it. I can sell. I can do whatever I want. Yep.
So judgment attaches to anything he owns, right? So they could go after something else before...
The judgment attaches to whoever the defendant is in the lawsuit. So in a slip and fall, who are they suing? No, in a slip and fall. The LLC, so the LLC becomes the defendant, and then the judgment can attach to any property that the LLC owns. So yeah, keep like connect the dots. Defendant Jordan, Jordan's assets. Defendant LLC, LLC assets.